evening, everybody. The question I was originally asked to talk about was, how can you defend some of these people who you've defended or supervised the defense of or helped defend? So people like that. And, the glib answer always is, everybody's got a right to a defense. But really, people's question is, how can you do that? How can you gain the trust of a child abuser? How can you be sure that your client, the murderer or the white-collar thief, is leveling with you? What if you do your job so well that he is unjustly acquitted and goes out to offend again? So what's a Constitution-loving Catholic, and for most of my career, military lawyer, to do about that? So there's much to say in a short time, so I will try to focus my 30 minutes in 3 areas regarding how the Constitution empowers, constrains, and counsels prosecutors and defense counsel in their behavior, tactics, ethics, and advocacy, and offer a couple thoughts from my experience. Apologizing, I'm losing my voice, so I'm going to take an occasional sip of pineapple juice. So first, let's spend a couple minutes on the Constitution. Our framers thought these points were so important that they codified them in that most magnificent of documents, the Bill of Rights. And just think about all they packed into 770 words, which is like the length of a op-ed column in the Post. And then I'll talk a little bit about the death penalty and conclude with a few minutes of remarks about war crimes in Guantanamo Bay. The major amendments affecting the criminal process are the 4th, 5th, and 6th Amendment, and we'll talk about them, as well as an honorable mention for the 3rd Amendment. The 6th in particular, is the great friend of counsel because of the authority it gives and because of the guarantees of public trials and all of that. So regarding the 4th Amendment, imagine yourself in a Boston suburb in the mid-1770s. And a woman, let's call her Mrs. Payne, yells to her husband who is tending the fire.
Honey, there's somebody at the front door. He's wearing a long red coat and he's got a musket. He says he's sleeping here tonight.
Don't let him in.
He said he wants some of the pamphlets we've been working on. And he's waving a piece of paper at me.
So you can summarize the main thrust of the 4th Amendment as, stay out of my house and don't touch my stuff. And if you want any of my stuff, you show me a warrant. Now, who are the people writing these documents? This is what in the shoot. Oh, I thought I had knocked something over. In the 1780s, their experience had been a couple years beforehand that soldiers would show up at your door and tell you they're there to pick their bedroom and maybe find out what you're having for dinner, because it'd be what they were having for dinner. And then while they're in there, they'd rummage through your stuff. So that leads us to the language of where's my thing here? 4th Amendment itself, and I won't read to you, I'll just give you a second to look at it. And you see the key things there. We see this a few times. It's the right of the people. So you do have the right if you're the guy on trial. But notice what was in their minds. It was a constraint on society, a constraint on government. So the people have a right to that security, which makes unreasonable searches and seizures contrary to the law. So it isn't just an accident that the 3rd Amendment precedes the 4th Amendment, because the 3rd Amendment, quartering of soldiers, still goes to the sanctity of your home and your dominion. And if it's going to be breached, it can only be breached if somebody gets a warrant, if the warrant is sworn, if the warrant is based on probable cause, and then you can only still take what's on the list. So a lot of intended limitations to make it harder to do this stuff. Not to make it impossible, because there should be the right amount of law and order, but to keep constraints so that people aren't giving up their freedom that they or their older brothers or cousins have just spent time fighting about. So let's go to the 5th Amendment and give you a second to read that as well. So just as in the Fourth Amendment, where we boiled it down to stay out of my stuff, the Fifth Amendment is you can't make me talk and you can't make me give you stuff or evidence. So a lot is packed into that, and I'm on the wrong, I'm saying fifth, right? Yes. The requirement for an indictment. So a prosecutor can't just come up and decide you're going to go to trial this afternoon. The charges have to be sworn out properly. You can't be made, the prohibition against double jeopardy. You can't be tried twice for the same offense. You can't be made to be a witness against yourself. And then property can't be taken from you for public use without just compensation. So the grand jury, the point of that is to put something between the government and the people. Who's on the grand jury? Farmers and everybody else, right? Car repair salesmen. So that if the government has some crazy idea, they've got to slip it past these people, convince these people who are on the grand jury. And the property can't be taken for public use, and we'll talk about that in a couple seconds. So you guys know, many of you know the Kilo case where the government condemned land for private development and claimed eminent domain to take the land that was going to be used to build like a shopping center in Connecticut. And we end up with just one of the more notorious votes, a 5-4 court decision that said they could do so. So who is the author of the dissent in Kilo that's a little bit paradoxical to people, who wasn't considered to be such a conservative as such, but was outside of the areas of social cases and religious liberty? And a person who had, you guys have to know this, so they'll make you turn in your YAF card on the way out, that who also was the only person on the court with experience as a legislator, therefore could understand better the issues in that case. And was the first woman on the Supreme Court, so we can move on. So she wrote a really stinging, 4-person dissent in there. So she's lumped in with the usual conservatives, Scalia, Thomas, whatever. But was the person who emphasized that case. There are, we talk about these cases in terms of one amendment or another as the kind of the shorthand, what's the issue in the case. But sometimes they do run together. So example of a case maybe 30 or so years ago where a guy shot somebody on the street, then went running into a convenience store, appears to stash something like behind the Rice Krispies. Cops come, get him, notice he has an empty holster, and say to him, "Where's the gun?" And he says, like, "Behind the Rice Krispies," and they get the gun. And the defense argument is, what there? What would the violation be there when he is asked? Yeah. Right, and what is our normal law on self-incrimination? What requirements are there on the part of the government before they can put you in a position to incriminate yourself? That's right, Richard.
Well, you have the Miranda rights now, but even then it said that you can't compel them in a criminal case to be a witness against himself. It sounds like he kind of freely admitted it. I don't know if that's what you're saying.
But the concession was exactly that he did. He clearly wasn't read his rights. He clearly was in custody. Miranda applies to any custodial questioning. So your custody doesn't mean you're sitting in a jail. It means you're not free to leave. But the court made an exception and just said there's a public safety exception. So the primary purpose of the questioning wasn't to get him to confess. The primary purpose was to keep the mom who's going to buy the Rice Krispies from reaching for the Rice Krispies and finding a revolver. So the court, again, by only a 5-4, makes that expansion of the Fifth Amendment. Give you a second to look at the Sixth. So there's a ton of stuff there. Speedy trial, public trial, right to a jury, right to know what they're charging you with, and the right to make the government bring witnesses on your behalf. So why speedy? Why is speedy trial a significant thing? Why is it now, and why would it have been in those days?
Then they could just throw you in jail and say, oh, your trial's coming, and just leave you there without a trial.
Right, and besides the deprivation of your liberty, what does that do to justice, right? Memories fade, and the government loves to have this kind of sort of Damocles there. You know, we could charge you, which has its own like coercive and demeaning aspects. What about a public trial? What do they mean there, and who like owns the right to a public trial? Is it the newspapers or is it somebody else? So I'm asking you too many questions at once. So why is a public trial something they wrote into those 770 words?
I mean, it keeps the power in the hands of the people rather than like a king or the state that might be able to have the trial and then they can just go get away with whatever.
In what respect does it do that?
Well,
How does it keep it with the people?
Well, the people can, like, they witness it and they see it and they can tell when there's something that goes wrong and when, like.
Exactly
it's
so.
figured out.
So the media sometimes will argue as though they're the holder of the right to a public trial. You know, they want a public trial because it's ratings and copy, right? But the right is the right of the people to drop in at any time, at any trial in America on any day, because then we're kind of like inspecting your work. So that's a real firm right. I was a newspaper reporter before I went to law school, while I was in law school. And it was a big issue at that time in the early 80s. Because a lot of the newspapers were being kept out of court when certain sensitive matters were being discussed. And there was a talk, like the prosecution agrees and the defense agrees that we can just shut court. And Supreme Court addressed it twice in a 2-year time, kind of fixing its mistakes from the prior year, and said, not the case. You don't own it. Society owns it. Virtually no circumstances under which we close it, though we do in certain classified cases that we can also talk about. So this is me as a sophomore in college before I wish I had prizes to give out, but you can read all the text there having to do with prosecution. You probably know that Kennedy only had one Supreme Court appointee, and that was this person here who is anybody here from Colorado?
Mark White?
Yes, known as what his nickname was. Whizzer White, All-American halfback for Colorado, and then Democratic Party guy and friend of the Kennedys, so he landed on the court for the only Kennedy appointment. So there's a lot in those words there, but he talks about, and you hear different, really kind of almost inspiring words about being a tribune of justice and the heavy responsibilities that a prosecutor has. So there really is, and it's not really self-importance, it's just that when you're in that field, you should have a little bit of a sense of solemnity and gravity to what you do. The prosecutor carries the case for the public, and the defense counsel makes sure the system works right and the accused person gets the defense that we've promised, whether he's clearly guilty, egregiously guilty, or otherwise. So this is how White, in his opinion, described the obligations and limitations on a prosecutor. Different deal as a defense counsel. And White here again talks about how a defense counsel doesn't have the obligations that a prosecutor has. And let me give you a second to read and then I'll talk. So as a defense, as I see you're still reading. I think we all know defense doesn't have to do anything at trial. Defense counsel can put his feet up on the chair, watch the whole trial, and at the end of the trial, stand up and say, they never proved it, sit down, and get acquitted. So there is nothing of any kind, and I'm probably saying what you guys understand, but there is nothing but the obligation not to violate the law in the course of defending somebody. But you don't have to be balanced, and White tells us here, you're at your best when you're not balanced. So you see, I know you all are young, but the famous scene in the O.J. Simpson trial was, a big mistake by the prosecutors, I think they realized instantly, was the murderer's gloves they had him put on in court. So this is him going like, and like, I can't get them on, right? Suggesting that he wasn't the murderer because the gloves that they trotted out from the crime scene don't fit him. Well, great exploitation by the defense. You all know the phrase made famous by Johnny Cochran, his defense counsel. Yeah, I mean, so, of course, the government walked right into that. And then there's the last on the defense, again, just saying, you can cross-examine anybody. You can't fabricate evidence, but you can point to any shortcoming in anything about the case because you're making the system work by doing so. Oops. Go up. One other point on here about appointed defense counsel in particular. I think Max mentioned one of my very first job in the Army was as a defense counsel, so I went instantly from law school to defending soldiers out in a military post in Oklahoma. And obviously anybody in the military has a right to a free public defender who is a uniformed soldier who for that period of time is serving as defense counsel. When I became the chief defense counsel then 25 years later, it was really important to me that to emphasize two things to our clients who are skeptical soldiers walking around military bases around the world thinking, that guy's wearing the same uniform that I'm wearing and I'm supposed to be able to trust him. He's wearing the same uniform as the prosecutor. Not so sure about that. There is also, for those of you with any military background, you look like a race car driver at sometimes because you have so many patches and stuff on your uniform, but in that you're communicating all kinds of information about you. On your left shoulder, you wear the patch of the organization you're currently a member of. So the defense, when it was stood up, now about 40 years ago, then when I was in charge, we had the 25th anniversary. They had always had just a generic patch, a patch that was used by the veterinarians who stamped the meat in the commissaries. So nothing that was distinctive about being a defense counsel. My two themes when I was the chief counsel were independence and competence, that you can trust our person. He's not on the take from the government, and he is as prepared, as smart as any prosecutor or any civilian counsel you could bring in. So we had a worldwide design contest where we asked our counsel to design a patch, and this is what they came up with. That little star in the cloud in the middle is kind of an homage to the original patch, which looked like that, and then you can figure the obvious concerns that it illustrates, including the sword as a matter of defense, the shield to defend against. So kind of a smallish thing, except a reminder to the skeptical or the doubtful that you can count on that person and they're qualified to defend you and won't sell you out. Before I keep going, any questions to this point? Anybody? Okay, this does remind me to give the disclaimer I should have at the beginning. I don't speak for anybody here, not President Kilpatrick, the law school, the Army. So I'm just offering you my own opinions. So when you try cases, you can find yourself in a position of trying capital cases, which I was on several occasions. Most recently with the Guantanamo Bay trials, where I made recommendations that the 5 chief terrorists all be tried in capital trials, and the woman who makes those decisions, the chief, the convening authority, approved it for 4 and not the 5th one. Certainly arguable point. The question for anybody, wherever your sense of ethics are or your faith, is, how do you square being involved in a capital case with whatever, your own ethics, the teaching of the church. So I had an experience early-ish, in maybe my I was 5 or 6 or so years in the military, now as a prosecutor in Germany. And we were investigating the murder by a sergeant of his son, who he shook to death. In doing that, we found out he was acquitted for killing a different son 11 years before that, and tried it as a capital case. So then I'm, 32 years old, thinking I should really take seriously the church's teaching on this. Went to talk to my boss and said, what are we going to do here? My boss was Dennis Michael Patrick Corrigan, so there was at least some understanding of Catholic culture, but had to come up with a decision of what to do. And he said, just let Peter do it, my co-counsel, who was an Irish Catholic, so that it didn't get us any farther. But had to deal with, what would you do if you got to the point that he was convicted and somebody's got to stand in the well of that courtroom and make a credible case for the death penalty? Ends up we didn't reach the issue, because now in recent decades, there is a requirement for a unanimous verdict on the findings. And we had an 11 out of 12. So therefore the defense, or the death penalty wasn't available in the case. But it of course arises from time to time, and I've assisted on a number of cases here and there over time. This shows the current state of play on the death penalty. It is moving slowly, but moving toward extinction. There are about 20-some cases a year spread across the states. So that map there you could probably figure out, right? The red ones currently have the death penalty, the black ones don't, and the blue ones are kind of on a pause. So the question is, you see some of the issues. Some crimes, the argument is, right, are so heinous that no other punishment, that punishment needs to be available to vindicate the value of that life. The other issue is dignity, and of course, what would the old Pope say? What would be the one word people most associate with him? Mercy, right? So those are all factors that have to be in your head. In assessing the ethics of it, you just look at the phases of a trial, right? Where does it come in to where you have, I'm forgetting the term, what's the philosophical term? I want to say material support, that's the legal term, but, right, yes. So you start at the beginning as the arresting officer, of course not. Making a recommendation to the district attorney as the junior counsel starts to come into play, right? The district attorney who submits a case as a death case, assisting the prosecutors, even if you're not actually trying the case, using it as a bargaining chip. We will put aside the death penalty if you plead to all these other offenses. Presenting the case on the merits, cross-examination, the argument on findings itself in that phase of the case. What about the trial judge who is managing the case? What about jurors? And we know the law provides that you're allowed to have what they call death-qualified juries. If a juror says they're just unalterably opposed to the defense counsel, then they can be excused and wouldn't be able to participate in the case. Arguing the appeal, being the judge on the appeal, mixing the chemicals that go into the IV that goes into the accused, into the convicted person. Most recently, right, we just had a death by firing squad a couple weeks ago. So the person who fires the weapon, you know, that we always go through these things where one of the people doesn't have a round in the weapon, so nobody knows for sure who does the killing, and you wonder is that like serious ethics, or are we kind of like tricking ourselves or talking ourselves into a resolution? But those are the issues in front of us on cases like this. William F. Buckley had talked about, a number of times, wrote a lot about the death penalty and a lot about pro-life issues, and was asked, you know, what's the difference between the fetus and a capital defendant? And he said, the capital defendant has due process. So it has made me think, just the number of times I've been involved with them, about, you always hear this, personally I'm opposed argument by some people on the abortion issue, which doesn't have much sway for me on the abortion issue, but I get it a bit in talking about these kind of cases. And the church's teaching itself, I want at least to have in front of us. Top one is from John Paul, when he said it should be, you know, virtually impossible to come up with a case or a scenario in which the death penalty would still have validity. Basically, the idea that you know, incarceration for the rest of your life is a sufficient sanction. And then Pope Francis used the term inadmissible, and then that last quotation is a revision of the Catechism on the current teaching. Switch for just a couple seconds, because I know there were some questions about Guantanamo Bay, how we got there, what we were doing there. To really boil it down, we were attacked by terrorists who were not members of conventional militaries. So we had a historic use of what are called military commissions, which is a confusing term, because when you're commissioned as an officer, that term is used. But military commissions were kind of colloquially referred to as war crimes tribunals. So a separate justice system operated exclusively under the military for the trial of certain combatants for war crimes. So this was the sort of acronym we used in describing who the people were who would be subject to trial. So you basically needed all four of these categories. First, so it's alien, unlawful enemy combatants. Alien, I think now people start to think of alien as sort of like a disparaging term. It's just a legal term. A non-citizen is an alien. Unlawful, and we'll talk a second about what makes somebody unlawful as a combatant and what tactics are lawful or unlawful. Enemy, and then a combatant. So not somebody who is engaged in the fight. And that doesn't mean they necessarily have to be shouldering a weapon. They can otherwise be contributing. So when a couple weeks anyway, after September 11th, I was in a job as a sort of a administrator for the Army at that time, and had just been promoted to colonel. Somebody from DOD came and said, start thinking about military commissions and put a team together to figure out. President Bush had wanted to use this mechanism that had not been used since 1943 to try alien combatants. So we sprinted over that fall, did put things together. The president signed an order on the 14th of November that put these into effect. Then we spent years fighting about them, and you probably know the 5 worst guys are still sitting in Cuba waiting for a trial that will happen at some point. We did, when I was the chief, we tried a few cases, but we've only tried a few over time. But in deciding what should this look like, what the question that I posed to my teammates was, let's look at what the law was in 1943 when the court unanimously found that to be valid. And these go back to the Lincoln conspirators as another example of people who are tried by military commissions. So some things had changed. Capital punishment went to that unanimity requirement that didn't exist in 1943 when all of them got the death penalty, and when the death penalty was adjudicated within 48 or 72 hours of the end of trial. So that's it seems like a different time, and was. Self-incrimination. We decided that we wouldn't apply Miranda to them because that's kind of purely the American legal system, but we would provide for the right against self-incrimination. So we could question you, you just don't have to answer. And a lot of these were, our point was that we weren't giving you rights because you're a non-citizen fighting us, you have no rights. The sovereignty of the United States is really important, and citizenship is a really important factor. So we're seeing that at play today, right, under this current era of the guys in El Salvador and all that. But citizenship has great consequence for what rights or protections you do have. And you're at the lowest level of protection when you're one of these guys. The other concern was that to loosen the rules of evidence. We have, which all practitioners love the rules of evidence and love the essential equity and logic that underlies them. But not realistic here, because stuff is carried off the battlefield. So, an ordinary scenario would be one of our helicopters comes down next to a cave in Afghanistan. A bunch of guys are in the cave that they've stuffed duffel bags full of hard drives and evidence and all this. Tie up the duffel bag, scribble a code on the outside, throw it into the helicopter, and it goes off eventually to land in like the DC suburbs to be analyzed by a bunch of smart guys. There's no warrant there, right? The Fourth Amendment isn't very robust under a circumstance like that. But our argument was, then you can argue about how much weight to give to that evidence, but it is properly acquired in light of the status of the people who we were dealing with. Two more aspects of that, and then to prepare to close. So how do you determine, what would your sense be about what factors you would look at to determine whether somebody is a lawful combatant? Actually, some of you guys probably know this, but these are just logical, they're not like special inside military knowledge. So somebody who engages with us on a battlefield or wherever it would be, what factors would you look at to determine whether they were lawful combatants, where then you can use in the terms of the law, you'd say a privileged killing. In other words, you kill somebody and you have no consequence to you because it's soldier on soldier fighting. Michael?
Would it just be the Geneva Convention? Like if they're using gas attacks, you know that's not a lawful combatant?
Right, so some of these do come from the convention. So the 5 factors are carry arms openly. So, right, that's giving notice to the other side. Follow a chain of command. Wear a visible insignia. Obey the law of war and be authorized by a party to armed conflicts. So the one that gets you, even if, we had arguments, especially during Afghanistan, where these guys would just like tie a do-rag to their head, and say that good enough for them in terms of the authority. But you have to obey the law of war. So if you don't conduct your operations in the law of war, you could have like a perfect steam-cleaned uniform on and salute your chain of command and not have any of these protections. The principles of the law of war are military necessity. It has to be a military reason to hit a location. Proportionality, kind of discussion we're of course seeing in the Hamas-Israel situation there. Distinction between combatants and non-combatants. So you have to faithfully do your best to avoid civilian casualties. And then humanity, unnecessary suffering, torture, proper treatment of prisoners of war. I mean, we have in our own heritage, in our own school, right? You all know the story of Father Capon, who, if you don't, you should look him up, is on his way to sainthood, or partial stop to sainthood, and was a soldier and abused in prison camps. Maximilian Kolbe, right, recent as well. You know, they just let him starve to death and die of thirst while he's, you know, singing hymns with the people while they're trying to wait him out to die. All of these worth our remembering. The purpose of this isn't for us to be nice or popular or anything else. The purpose is, I guess I wouldn't say completely, but primarily one of self-interest. We obey the rule of law because we want to get to the peace, and you are more likely to have the opportunity for peace and for an enduring peace if you played by the rules and fought by the rules along the way. So it's not so much sentiment that we want to be good in the abstract as it is military effectiveness and doing the best for your country. One last example. We have still, over recent times, continued to use landmines while this and that convention have outlawed them or minimized their use. And we have minimized our use, but we still use them. When I was in Bosnia, I was the chief lawyer for a 14-nation division. And we had differences among ourselves on mines, so we had to work it out. We had Russians and Norwegians and a bunch of others in that coalition. Now the United States basically is pledged to not use them except to use them in Korea for, because the chance of overwhelming the border is so great that using a sort of a blunt instrument like a mine is best way for South Korea to be able to relax at night. Couple thoughts just to close. Any of you who might be inclined to practice, you know, it is like unglamorous preparation. I mean, there are times in the courtroom it's really fun to be in the courtroom, but it is all about out preparing the other guy and rehearsing and keeping straight from an ethical standpoint. I know in my early time trying cases, all you're doing is thinking, can the other guy be just a little dumber than I am? And then you try cases against smart people and think, oh, this is easier. This is like more just and more fun. So a well-prepared ethical opponent is like the best thing ever, because you're much more likely to produce justice and you are likely to sleep better at night. So, recommend appropriately. I've said for the last time, the significance of what you do, the gravity of what you do, not in a way that's intimidating and not in a way that's boastful. Just, society has given you serious stuff to do if you represent society's interests in trying a case, and awesome responsibility as defense counsel. The first time you're in a courtroom and you look next to you and it's just you and him, you are struck by how consequential the advice is that you'll give to somebody and the potential impact of it. And it is all how you prepared, how you gained that person's trust. That's all I have for starters. Thanks you all, and if anybody has any questions.
So if anybody has any questions, feel free to line up in the back on the right, and then just speak into the microphone for the live stream recording. We have minutes for questions, so don't hesitate.
Hi, Colonel. I was hoping you could just tell us a quick story about your experience, perhaps a case that you think, whether you prosecuted or defended it, that you think was absolutely wrongly decided.
I don't know a case that was wrongly decided, but I'll mention two cases just that kept me alert and thinking as I went through each case. I had a case, a guy named Sergeant Larry B. Johnson, who was a black belt Army sergeant, real strong performer, and was charged with rape of a 19-year-old, like PFC maybe, from Baraboo, Wisconsin. So she was young and really white, and he was 6 or 8 or 10 years older, and really dark-skinned, athletic-looking, powerful-looking guy. At any rate, they arrested him for rape of her in an off-post hotel in Oklahoma. There was a prosecutor who had nothing else to do because he had shattered his leg, so he was just waiting to get his leg fixed to leave the Army, and was really focused on that case and worked on it for more than a year's time before they indicted, though we don't use that term. Now I'm trying to remember if he testified, which is an important part of it. Anyway, went to trial and was not convicted of rape, but was convicted of aggravated sexual assault, a bunch of other things. So, you know, I don't think race is always an issue when you have, you know, two people of different race, but it can be an issue, and it was a reminder to me just to keep head on. You know, you don't know what your, so I got too invested in my client too, I do remember that, because I thought it was unjust, and I was, right, my first tour, so I was still really young and really righteous, and thought the government had lost its bearing in the case, and that a factor may have been, you know, she was young and cute, and he was older and more powerful looking. So I don't have a case where I think there was an outrageous outcome, but some that you just, you know, kind of churn in your mind.
Any other questions, especially you guys in the military?
Questions for both?
Yeah.
First of all, thank you so much. I really enjoyed this. I don't really know a lot about military law, so I was just curious because I know you said that people that are not from the country, they have the right to not self-criminalize themselves, right? To a certain extent, like they can not say something if they don't want to, right?
Yeah.
So would that be tried in international court, or like, and how would that work?
Yeah, that's a great question about international court. It takes you back to the point I was trying to make, maybe did, about sovereignty and citizenship. So we got a lot of, when we were working on getting these cases, working on getting the president's order right after 9/11. And then once the president gave us the order, then we went right into writing the rules. So we basically took kind of a body of military law and then looked at each piece and think, does this apply or not here? So the right against self-incrimination, we decided, and I think it was held up in court, in America now, in an ordinary case, applies as soon as your freedom is restrained, as soon as you're in custody. We read you your Miranda rights, and then you don't have to talk, which is meant, you know, this was just a 1965 decision saying that the system was too out of tilt, that people get manipulated by the cops and to give up their right against self-incrimination. So you've got to give them that warning. Mm-hmm. But the right, really, when the Constitution was written, the right against self-incrimination attached, you know, became active only when you got into court. So it meant you couldn't, because the terms say, right, cannot give evidence against yourself. So it applied then, not in a Miranda setting where it applies way sooner. So we decided that better to apply the non-Miranda version, which is still consistent with the Constitution, though not the case law there. So the thought was you're still giving a procedural protection. We're not making you get up from your chair and talk, but not having the complexity of having it apply earlier.
Okay, thank you.
Hi, thank you for coming. I was wondering if you could speak a little bit more about the role of the defense, particularly in the quote you put up about the prosecution. It said, I think, something about the primary goal is justice. You're aiming for justice. But then the defense, it didn't seem quite that clear cut. I'm all for it. Like if you think a witness is lying, for example, like trying to point that out. But then it said a couple other things about like trying to confuse them, and it wasn't quite clearly directed at justice as it was in the case of the prosecution. So could you explain that a little bit more?
Yes, and I meant to talk about that. I was going to ask you all how much you think whether the defense counsel, because you hear so often, and I think we tell ourselves too, that when you're defending some of these guys, who you have to defend with as much zeal as you do somebody who gets charged with, busting into a 7-Eleven, is to what extent does the defense counsel have an obligation to be a guarantor of justice in the system? In other words, is he kind of like a roving good guy who helps the process be straight and maybe calls some flags or something? And the answer, as White tells us, is not at all. Not a little bit, not dependent on the setting, not with some kind of shade, or not if you're really like a superstar. It's you have no obligation of any kind toward the system other than not to do anything that's corrupt or corrupting. So otherwise you figure out, where does that start? When do you throw them like a half of a lifeline? And it is hard for people. When I was in this job, would have to go around and recruit young captains to come become defense counsel, and so many would say, my conscience can't let me do that. And my charitable reply was, then you need to really think about your time in the military, because you took an oath to uphold and defend the Constitution. This is an exercise in the Constitution, so you kind of need to get with it. So I understand it all, and it is, I put it there because it was so stark, and because it comes from a pretty moderate guy on the court. And White was, his area of expertise was criminal law, so he wrote more about criminal cases and wrote from a kind of a conservative perspective. So to go on at some number of paragraphs saying essentially defense counsel can do what he wants, I think the question almost is, has he crept us pretty close to the line? When you cross-examine somebody under circumstances that are likely to be untrue, are you in a shady spot? And I think from a legal standpoint, and our ethics might be different. There's no obligation at all.
You.
Good evening, sir. Would you be able to talk about Guantanamo Bay and how enhanced interrogations affected your job?
And how what?
Enhanced interrogations affected your job?
Yeah. Question is about interrogations in Guantanamo Bay or other locations. And you all probably know there were some number of techniques that were used over the years of time that we were fighting that war that included, probably most well known is the waterboarding, to get the sense of drowning, to overcome your vulnerabilities and get you to talk. There were dogs used as well, right? Not to bite, but to scare and other stuff like that. Was probably the most complex legal issue that we dealt with there. Those other issues we talked about that relate to sovereignty and status were important, but we had them figured out pretty well. This was more difficult because we couldn't control the behavior of, whatever had happened some amount of time before us. So to shrink it a little bit. The question was, what, if any, use, excuse me, what, if any, use could we make of those statements that some of those terrorists made as a result of those techniques? So, you know, the term we use in just regular domestic law is to overbear your will against self-incrimination. So did they, to that extent? So you still have to tie it to some piece of law somewhere. But we decided to, and it's just, I guess, not fully in play, to make minimum use of those statements on the idea that obviously if they put the information there, it would be a pretty fertile area for defense counsel questioning, right? And we tried to recreate them. A really smart guy who was working in the task force when I joined it took charge of what they call a clean team. So a bunch of lawyers from all around the government, you know, military, but also DOJ, FBI, others, and went back and re-questioned any of the principal accused who had previously been given statements. And they're called cleansing statements, that then you throw out the old statement and use the new one. As you're probably thinking already, kind of a problematic thing, right? The courts talk about a cat in the, what is it called? Cat out of the bag theory. Like, you think I'm stuck anyway, so I'll go ahead and talk. So it has remained, and we litigated them some and lost some and won more. We would concede that that an accused may well have perceived that he was required to talk, or that now they're giving him an opportunity to tell his story all over again, but if you don't cooperate with us, then we'll be back to like the old stuff that we tried before. So what we did that worked okay, worked as best as you could ask, was took that objectionable or potentially objectionable evidence, used it to frame a cleansing set of questions, executed on those cleansing statements, and then tried to use them in court, and on a number of occasions were. One last piece of an example is we really wanted to, and I really wanted to, have the cases as open as possible. I thought we should truly have allowed them to broadcast them on Al Jazeera, and that never went anywhere. But shoot, what was I about to say about that? I just lost my own train of thought. What was your last question? Oh, about how we, so in general, the courts, we were straight up with the courts, but there were a number of other pieces of highly sensitive information that were gathered by the United States in means that we wouldn't want to share with somebody. So this isn't illegally obtained evidence. This isn't products of torture or whatever. I think torture was misapplied term. I mean, it was a polemical term, out in the world. But I'm trying to keep two thoughts in my head. To take evidence that comes from satellites and things like that we are never going to walk into a normal courtroom and put it in. There is a provision in the law that's also in the civilian law where you can take the evidence to a senior person in government. So it'd be, we had like the admiral who was in charge of that theater of the world, who we would take the classified evidence, boil it into an unclassified summary. So instead of having all of the chatter that you pulled out of the world, it would just say like, Dick shot Jane or whatever. And that authority would look at it. The military judge then would determine whether that was a fair approximation of the classified stuff, and then permit you to put that into trial. I remember having talked about the Sixth Amendment and the desire to be able to confront witnesses and how important that is. The defense in those situations, of course, are like, I'm trying this case in a black box because all I get is this piece of stuff, this conclusory statement that the judge had said is okay, and I can't really go behind it to cross-examine the source or the person there. And I think in that circumstance, really the government's response is, yeah, that's as much as we can do. You know, we are bending as much as we can, and to be able to have justice that doesn't cause us to risk other aspects of our national security is more than we should want to do. And that accounted for the reluctance of some of our senior policy makers on, is it worth all of this risk? One last thing, we had mentioned the death penalty, and you mentioned an international tribunal. That was what I was originally going to answer. There was a lot of argument about, shouldn't you set up an international tribunal like The Hague for the Yugoslav, war crimes, or like Nuremberg, the sort of gold standard from the 40s. And our administration was pretty strong. I had a lot of arguments about a lot of stuff with them, but on the ball on a number of things. And on this, their point was, United States was attacked. There did happen to be 60 Brits and a number of other people from other countries, but it was an intentional attack on the United States, and use of the justice system is a fundamental exercise of sovereignty. So we're just going to go it alone. That had collateral impacts because there were like Malaysians and others who had really important evidence for us who refused to give it to us so long as we made the death penalty available. So they would only give it to us in cases that were not death eligible, which just was another complicating factor. And we weren't determined to put everybody for the death penalty, but those were the most complex cases, and that was hard nut to crack.
We have time for one more question.
Hello.
Yeah.
I was also going to ask about torture, so I'm shifting to a less austere question. What would you recommend, just because right now, based on current administration and everything, like everyone and their mom is all of a sudden an expert on due process and rights of citizens, non-citizens, et cetera. So there's a lot of misinformation or heated information out there. What sources would you recommend people go to for what the United States actually holds in these areas, or other recommended reading to fill in the gaps of some of the questions that we didn't know tonight?
Actually, I was, to tell you the truth, I was fooling with a reading list that I could give out, but I ran out of time. So I could publish that if I want. The key thing to think of from due process is defined in our law. We just look at notice and an opportunity to be heard. And that's manifest in a bunch of different ways. If you're determining whether, a kid stole a candy bar from the 7-Eleven, it's minimal of both. But when you're looking at these situations, it just reminds me, somebody had sneaked a picture of Scalia on one of these slides, I think just to see if I was paying attention. But he was great about due process and serious about it. And I think the quote was, I remember the exact details. Was that the due process clause applies to disputes regarding citizenship. So I think my own sense is the cases are a little clearer than the politicians are letting on. I don't have a great source on due process itself, but every statute or regulation that's being followed or disputed or talked about there has in it some amount of notice, some amount of opportunity to be heard. So if you stumble off a plane in El Salvador and we're like, shoot, we meant to have you in South Dakota, that the government takes some kind of action, it has to at least let you know, this is the status that we believe you are under, here is the action that we are preparing to take, what do you have to say about it? So the notice is the government telling you what it got, and the opportunity to be heard is whatever that statute or regulation says, but is my ability to present my case. And it might, depending on the circumstances, could be an in-court hearing, could be an exchange of paper, but it is at least important to have both of those elements covered.